If you're like me, you will have enjoyed reading the legal commentary that's been published ahead of the Supreme Court's oral arguments in Dobbs v. Jackson Women's Health Organization on December 1. At issue in the case is Mississippi's 2018 Gestational Age Act, which prohibits abortions after 15 weeks of pregnancy, with exceptions for medical emergencies and severe fetal abnormality. The scholarship on the issue, both in formal amicus briefs and in longer form essays, has been richly educational. That so many constitutional law professors, advocacy groups, and nonprofits have decided to submit their thoughts for consideration isn't surprising, given that this is perhaps the most consequential case the court has decided to take up in decades. Mississippi's law, although modest and broadly popular, is self-evidently incompatible with the court's prior rulings, and therefore threatens the abortion regime that's been constructed over the past half-century. I was surprised, then, when I learned that the Cato Institute, the prominent libertarian think tank in Washington, D. C, which boasts a center dedicated to the study of constitutional law, has decided not to file with the court in this case. Surprise quickly turned to confusion when I read Ilya Shapiro, the center's director, on its justification for not doing so. Let's consider each reason in turn. First, I'll take Shapiro's word for it that libertarians, both at Cato and elsewhere, hold a range of views on abortion. Yet maintaining a wide range of opinions on abortion does not preclude Cato, or any of its fellows, from opposing Roe and Casey, which they ought to do on constitutional principle alone. Indeed, any pro-choice libertarian in good standing should advocate exactly this position. More on this below. Next is the admission that they don't have anything unique to add about what constitutes an undue burden, the standard established in Planned Parenthood v. Casey for determining whether a state restriction on abortion pre-viability is legitimate. As a constitutional matter, this is fair enough. The undue burden standard has been sufficiently, even exhaustively, examined. Take, for example, a brilliant new essay from Mary Ann Glendon and O'Carter Snead in National Affairs. In making the case for overturning Roe and Casey, they note that the standard has been an exceedingly vague concept since its creation. The new standard, they write, it failed, yet again, to ground the court's abortion jurisprudence in the Constitution. As it so happens, made-up rules tend to beget more made-up rules. Consider, too, this brief description from Chief Justice John Roberts, on the sort of balancing act that Casey demanded. There is no plausible sense in which anyone, let alone this court, could objectively assign weight to such imponderable values and no meaningful way to compare them if there were. So, in short, yes, Casey is well-trodden ground.